President Donald Trump said this week that he will move forward with his plans to draft an executive order that would end the practice of granting citizenship to children born in the U.S. to non-citizens. Speaking at a rally Thursday in Columbia, Missouri, Trump said that Democrats are behind the crazy and lunatic policy, which has created a birth tourism industry. The Democrats want to continue giving automatic birthright citizenship to every child born to an illegal immigrant, even if they've been on our soil for a mere matter of seconds, he said. Hundreds of thousands of children born to illegal immigrants are made automatic citizens of the United States every year because of this crazy, lunatic policy that we can end. Trump supporters argue that one key phrase in the first section of the amendment, subject to the jurisdiction thereof, offers the president legal room to assert that people in the country illegally cannot give birth to U.S. citizens. The issue of birthright citizenship hasn't been tested by the U.S. Supreme Court for 120 years, when justices issued a ruling allowing children of legal aliens to automatically gain citizenship status. However, most constitutional scholars say an executive order would violate the 14th Amendment. Since it was adopted July 9, 1868, the U.S. government has held that the 14th Amendment confers the right of citizenship to all children born on U.S. soil. What does the 14th Amendment say about birthright citizenship? The amendment covers a number of issues, including defining how political representation would be apportioned among the states. However, the first section is most critical, as it defines what constitutes a citizen of the United States. The key passage reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." The amendment goes on to define the rights of those citizens. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That language is pretty explicit, said George Rutherglen, a professor at University of Virginia's School of Law. It's very hard to get around that constitutional language, he told dailymail.com. I don't see any way around it. What are the arguments against birthright citizenship? Nonetheless, Trump has said that he can do just that through an executive order. We're the only country in the world where a person comes in and has a baby, and the baby is essentially a citizen of the United States. With all of those benefits, Trump told Axios in his interview announcing the proposed policy change. It's ridiculous. It's ridiculous. And it has to end. It is worth noting that more than 30 countries, including Canada and Mexico, do allow for birthright citizenship. A minority of experts have made the case that the 14th Amendment's line that reads, "subject to the jurisdiction thereof," refers to people who owe an allegiance to the U.S. For example, green card holders and citizens, said Sheldon Gilbert, a senior fellow at the nonpartisan National Constitution Center in Philadelphia. The opposing argument is basically that, if you do not owe allegiance to the United States, you do not have citizenship, Gilbert told Daily Mail. Trump has also zeroed in on the jurisdiction line of the 14th Amendment, though he hasn't specified what his legal argument is. The overwhelming balance of legal scholars and historians argue that the 14th Amendment requires birthright citizenship, Gilbert said. Most scholars also agree that the line about jurisdiction was originally included to distinguish the lack of a birthright for children of diplomats visiting the United States, as well as for Native Americans who at that time were considered under the authority of the United States, but members of a sovereign nation. Michael Anton, one of Trump's former national security officials, recently argued in the Washington Post that the president had the authority to use an executive order to specify to federal agencies that the children of non-citizens are not citizens just by merit of being born on you. Soil.Still, a majority of constitutional scholars rejects that notion. There's also a very deep practical problem, Rutherglen said. Suppose Congress or the president repealed this provision. How would I prove I'm a citizen? I've got my birth certificate, but it doesn't say my mom and dad were citizens. And theirs don't prove that they were citizens. So you would have this chain of inquiry that would go back for generations. What is the history behind the 14th Amendment and citizenship? The 14th Amendment was adopted July 9, 1868 as part of a Reconstruction effort following the American Civil War. It was a controversial action at IMN at the time, and bitterly opposed by states that had been part of the defeated Confederacy. It was specifically put in to first handle the problem of slavery, what to do with the citizenship status of the slaves freed by the 13th Amendment, and what to do about the increasing presence of Asians, Chinese in particular, on the West Coast, Rutherglen said. Share this article. Share the ratification of the amendment put an end to prior legal precedent established through the 1857 U.S. Supreme Court decision in the Dred Scott case, which held that black slaves, whether enslaved or free, could not be American citizens. While Lincoln's Emancipation Proclamation of 1868 freed slaves in the southern states, African Americans still didn't have the same constitutional rights as citizens. Any tampering with the 14th Amendment looks like an endorsement of Dred Scott, Rutherglen said. I do not know of any constitutional scholar who wants to go back in that direction. That's the worst decision in U.S. Supreme Court history. What has the Supreme Court said about birthright citizenship in 1898? The U.S. Supreme Court issued a decision in a case entitled the United States.The, which cited the 14th Amendment in its ruling that a Chinese immigrant's child was an American citizen. That decision has stood for 120 years, but was decided before the concept of illegal aliens was commonplace in this country. Some opponents of birthright citizenship have argued that the decision failed to address people in the country illegally, as the child in was born to immigrants who were legally in the country, so they were bound by an allegiance to the U.S. Gilbert said. To that point, the Supreme Court has never tested birthright citizenship in the 14th Amendment when applied to immigrants who are in the country illegally. More recently, at a dinner party in 2010, then-Justice Antonin Scalia said that purposely including the words "and subject to the jurisdiction thereof" suggested that people born in the U.S. weren't automatically citizens, especially if they were subject to the jurisdiction of some other nation. He thought the words were included to rule out a large number of people. Scalia, who died in 2016, allowed at the time that the way the modern U.S. interprets dual citizenships could also mean many people be subject to the jurisdiction of more than one country. What happens if Trump signs an executive order if the president orders that the federal government must treat children of illegal immigrants born in the U.S. as non-citizens, it would almost certainly face major legal challenges. Most likely, civil rights groups would seek out a poster child to bring a lawsuit against the government, perhaps a child born in this country to illegal immigrants who was denied a U.S. passport or access to public benefits only offered to American citizens, Rutherglen said.